Very intimidating. Good morning, everyone. If people could take their seats. Welcome, and thank you all for being here. I'm Dean Reuter, Senior Vice President and General Counsel of the Federalist Society. It's my pleasure to welcome you to this year's Federalist Society National Lawyers Convention. I want to start with a show of hands, if I could, show of hands. How many of you went to the Mayflower Hotel this morning? Nobody. All right, well, you people are the smart ones, so thank you for paying attention. Also, a personal request. People will continue to arrive over the next few hours. Please don't tell them that I said that you were the smart ones. But I'm glad to see you here, and thank you for making it in. I also want to welcome everyone who's watching on live stream, and I want to give a special shout out and thanks to our donors. Sadly now, for those of you who have not heard, one of our legal legends, former Solicitor General and U.S. Supreme Court litigator extraordinaire, Ted Olson, passed away earlier this week. The Federalist Society will have a more proper commemoration of his legacy later, but for now, please join me in a moment of silence. Thank you. I am 100% confident that Ted would want us to carry on, and so we shall. So welcome once again to the Federalist Society National Lawyers Convention at the Washington Hilton Hotel, a phrase that does not quite roll off my tongue yet. Of course, being here at the Washington Hilton Hotel does remind me of a story. And this story is a little, not as lighthearted and funny as some of my other stories, but some 404 years ago, this very month, 102 adventurous human beings were aboard a small vessel in Europe, having set sail for the United States of America, which, as you know, was at the time not even known yet as the United States of America. With a nod to the future and hope in their hearts, they referred to this continent as the Promised Land. Men, women, and children, families, and a crew of 30 were aboard that small vessel. 10 weeks the voyage took, an eternity, their future uncertain and unknowable, surviving in the cramped confines below deck, rarely seeing daylight. Those hardy souls crossed a perilous ocean and found both comfort and consolation in the snugness of the ship, bobbing wildly upon the waves and swells through one storm after another. Ultimately, though, they successfully reached the next stage of their journey. Those 100-plus people left the ship, the Mayflower, left the Mayflower adventure, and began their American adventure. It is not without some sense of loss and even trepidation that we here at the Federalist Society enter the next stage of our journey, a new adventure of our own, leaving the comfort and confines of not the Mayflower ship, but the Mayflower Hotel. You can see what I did there. This seems like unfamiliar territory, uncharted waters, but this is really just the next step in the growth of our organization. And the relocation really is a sign of the organization's success, which I attribute to you, the Federalist Society's tried and true members. And because, please spread the word on this, because of the move from the Mayflower, we're able to welcome record numbers of you to this year's convention, literally hundreds more of you today and tomorrow and Saturday. Importantly, thank you to the Federalist Society staff. I can tell you they are doing their best in these unfamiliar halls to make your experience a terrific one. The staff are wearing the name badges with the red ribbons. If you ask them for help, directions, details about the facilities, I guarantee you that they will pretend to know the answer. But they have access to the books to tell you where to go, so please look them up. Now, before we really get started in earnest, we're going to have a very short video put together by the Federalist Society digital team, documenting some of the history of the Federalist Society and the National Lawyers Convention. Just a couple minutes. So please pay attention, though. You might see yourself in this video. So let's roll the video.
We thought we were just planting a wildflower among the weeds of academic liberalism, and it turned out to be an oak.
Let me welcome all of you to the first annual Federalist Society convention here in sunny Washington, D.C.
You are insisting that the Constitution is not some elaborate inkblot test.
We've got to remember separation of powers, how this thing is supposed to work.
But more than that, the rule of law guarantees the process whereby democratic institutions can rise, grow, change, and flourish.
I think one ought to be an originalist because the Constitution, no less than a statute, is law.
Our role is to say what the law as enacted is, not to forecast what the law as amended will be.
Conferences like this prove that civil discourse is alive and well in our society.
It is our duty to stand firm in the defense of the constitutional principles and structure that secure our liberty.
But when I come here to the National Lawyers Convention and I think about what the next few days will bring, I cannot help but feel rejuvenated and optimistic.
As we get started, a few logistical items. If you're seeking CLE credit, it's important that you sign in now with the QR code that you can find in the program and elsewhere on the premises here. But don't forget to sign in, and then at the end of the day, sign out. Do that every day, and you'll be fine. Please make sure to visit the Rare Documents exhibit put on by the Remnant Trust. They're back again with us this year. The exhibit can be found in the Cardozo room on the terrace level of the hotel. It is once again, I think, a terrific collection of first edition volumes of importance in American and Western history. Turning now to our program. Delivering our opening remarks for this year's convention is Judge Andrew Oldham. Judge Oldham currently serves on the United States Court of Appeals for the Fifth Circuit. Before ascending to the bench, he served as general counsel to Texas Governor Greg Abbott, where he advised the governor on a range of issues under federal and state law and managed litigation for the governor. Before that, he served as Deputy Solicitor General for the state of Texas, representing Texas in federal courts across the country, including twice before the U.S. Supreme Court. Before moving to Texas, Judge Oldham was an attorney in private practice, I think not really big law, maybe medium law, at Kellogg Hansen here in Washington, D.C., where his practice focused on appellate litigation in federal courts. He also worked as an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice. Everyone here knows that's the part of the government that houses the lawyers' lawyers. And Judge Oldham also clerked for David Santel on the D.C. Circuit Court of Appeals, and then Justice Samuel Alito on the U.S. Supreme Court. As to educational credentials, Judge Oldham earned a BA from the University of Virginia with highest honors, a Truman Scholarship for graduate school, an MPhil first class with distinction from Cambridge University, and a JD magna cum laude from Harvard Law School. He's just so smart. How smart is he, you ask? He's so smart that he and I had a dinner recently, and I just went ahead and put in for CLE credit for the time I spent. And it got approved. So you can read all his credentials, everything I've said except that last bit, in his bio or Wikipedia page. But what you won't find in those official records is yet another important, defining, and all too rare characteristic. And that is, Judge Oldham is an extraordinarily kind and decent person. And on that basis alone, I'm honored to introduce him to you. Judge Oldham.
Oh, it is such a great honor to be here, and thank you, Dean, for that incredibly kind and gracious introduction. Thank you to the Federalist Society for having me. And oh my gosh, how excited are we about last week's blowout victory. By which I obviously mean the University of Texas Longhorns beating Florida. That's right. Thank you very much. I'm glad the Texans are here. I joined the Federalist Society more than 20 years ago when I was in law school. And as far as I can recall, I have attended every convention since. I joined the Federalist Society because it was a very, very unique place for free and open debate, one of the only such places at Harvard Law School. And that has remained true over the decades. One of the great things about the Federalist Society is that we do not always agree. In fact, we rarely do. That is in many ways the point. Paraphrasing John Stuart Mill, truth is made in the struggle between combatants fighting under hostile banners. And it is an honor to be surrounded by so many worthy intellectual combatants this morning. Now, if you have been around the Federalist Society for half as long as I have, you have probably heard someone say, quote, "The Federalist Society takes no legal positions," end quote. And that is obviously true in one sense. There is no secret FedSoc manual that tells me how to decide qualified immunity cases or what the original public meaning of the First Amendment is. But it's not true in other senses. The state exists to preserve freedom. The separation of powers is essential to our constitutional republic. The province of the judiciary is emphatically to say what the law is and not what it should be. Does that sound familiar to you? Because it should. That is a mantra that we say at Federalist Society events all over the country. If you've spoken in FedSoc chapters or attended FedSoc events, you've heard it so many times that it risks losing its power. But no part of that tripartite statement is self-evident or universally accepted. In fact, all three prongs of it are hotly contested. These are normative principles about how law should operate. And embracing them is, make no mistake, taking a legal position. So in honored FedSoc tradition, we're going to spend the next few days listening to and participating in debates. And that's wonderful. But when it comes to the principles that are essential to our constitutional order, we should not be shy or agnostic about taking a position. This morning, by way of introducing our conference, I'm going to discuss two more such principles that require much less debate and much more defense. The first principle is as old as the Republic itself: judicial independence. If you know me, you know that one of my principal passions, beyond being a judge, is that I think every single law student should be exposed to at least one conservative legal voice during law school. It's a radical proposition, I know. So at great cost to my family and occasional costs to my gym habits, I like to teach at law schools. My favorite course to teach is federal courts. And one of the first lessons I teach to my Fed Court students is the difference between an Article III judge and a non-Article III tribunal. The difference is simple and profound. Article III judges enjoy life tenure and salary protection. Both of these were of great concern to the founding generation, so much so that they were included in the Declaration of Independence. One of the colonists' grievances against George III was that he made judges' tenures and salaries dependent on the king's will. And as a response, early Americans enshrined life tenure and salary protection in the Constitution. Why are life tenure and salary protection so important? Because as Hamilton explained in Federalist 78, these are the guarantors of judicial independence. Independence from what? Well, for Hamilton, the answer to that was twofold. First, the federal judiciary should be independent from the whims of the majority. And second, the judiciary ought to be independent from the other branches of government, most notably Congress. Otherwise, as Gordon Wood put it, legislative control over judges would make them liable to being tossed about by every veering gale of politics. The Federalists saw this independence as critical to principled judging. Judges must be free to focus on the Constitution's original meaning without fear of personal reprisal from the legislative branch. Why, you might ask? Because that is the only way to guarantee that judges play their role in policing the separation of powers. After all, the power of judicial review would not do much if courts were controlled by the very legislature whose work we are tasked to judge. Finally, Hamilton argued that judicial independence was critical to protect individual rights. The Constitution set up a system of limited government in large part to protect the individual rights of the people: freedom of speech, freedom of religion, the right to keep and bear arms, the right against uncompensated takings. The list goes on, and if we have learned anything in recent years, it's that those who need the law most are often those who the polls favor the least. Now, make no mistake, judicial independence was not a foregone conclusion at the founding. In fact, the Anti-Federalists were often quite critical of it. Brutus, for example, questioned why our Constitution departed from England's model, in which the judges were subservient to Parliament. Brutus also worried that federal courts would collude with other branches of the federal government to denigrate the states. And Brutus famously worried that judicial independence would make federal judges all-powerful. In his 15th essay, Brutus said of federal judges, "They are independent of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself." Now, you might be asking, was Brutus right? I mean, we've had some pretty egregious examples of judicial hubris over the course of American history. But the important point for present purposes is this: true, men are not angels. If they were, as Madison famously said, no government would be necessary. But the fact that judges are not angels does not give us license to start over, nor does it mean that we should treat the judiciary as if it were one of the political branches. It is precisely because we are not governed by the cherubim and seraphim that we need a strong and independent judiciary. The whole system of government depends on ambition checking ambition. And up to this point in American history, the judiciary has weathered some serious attacks. In the election of 1800, the Democratic Republicans won a decisive victory. Thomas Jefferson took the presidency, his party won both houses of Congress, but that victory was not enough. The Federalists controlled the court, so the Democratic Republicans came up with a plan. They would impeach the sitting Federalist justices, starting with Samuel Chase. As one senator argued, Chase had, quote, dangerous opinions, so he must be replaced. And the House approved articles of impeachment against him based on various, quote, legal errors. Now, the Senate acquitted Chase on all counts, and the attempt for his impeachment was such a failure that even President Jefferson described it as a farce that will not be tried again. And today, that episode reminds us that when we disagree on the law, we do not kill the referees or change the rules of the game. Fast forward to perhaps the most famous attack on the judiciary, FDR's court packing plan. In 1937, FDR provided a handful of pretextual reasons for his plan to add new justices to the Supreme Court. But his real reason was the disagreement over the outcome of specific cases involving the New Deal. If the court disagreed with his preferred interpretations, FDR would jerry-rig a majority of the court to give him a win. The Senate Judiciary Committee eventually rejected the plan, and it did so explicitly on the grounds that court packing would undermine the independence of the judiciary and threaten the separation of powers. All of this is to say that attacks on our courts are not new. Proposals like term limits, forced retirements, court packing, even impeachment have arisen from time to time since the founding. Still, some of the recent attacks do seem different. A man allegedly flew across the country from California to Bethesda to assassinate Justice Kavanaugh. He was allegedly found outside of the justice's home, wearing all black, carrying a pistol, ammunition, zip ties, a knife, pepper spray, a hammer, a screwdriver, a nail punch, a tactical knife, and padded boots. Another man was indicted for threatening to kill or torture justices and their families by hanging one from an oak tree and, quote, putting a bullet in the head of others. all because he disagreed with their decisions. Folks apparently think nothing about tweeting the justices' home addresses whenever they see a, quote, hot legal take on Twitter that stokes their anger, and apparently some think that the justices' spouses are also fair game too. Now look, there are topics that we can debate in this space. We could debate the line between criticism and demolition. We can debate whether these present attacks are different in kind or magnitude from those that came before. We can debate root causes, we can debate remedies, and we can debate responses. But one thing that is not open to reasonable debate is that judicial independence is essential to our constitutional system. And because the separation of powers benefits all Americans, we share a common obligation to defend it from attack. That is a legal principle, and there is no reason to be shy about adopting it. Now let's talk about a second legal principle. In America, we do not settle political disputes in courtrooms. And an important corollary of that principle is that the political branches use elections and democracy to settle their disputes, not the power of prosecution. And again, we have not always honored this principle. Consider two examples of prosecutions lodged in the middle of political campaigns, neither of which ended well. First, recall the founding era and bitter rivalry between the Federalists and Democratic Republicans. In the 1790s, tensions were incredibly high. Our new nation was on the brink of war with France. Each party believed that the other would destroy the country. Federalists called the friends of Jefferson and the enemies of the United States. Democratic Republicans called Federalists apostates and internal foes. Now, there's no word yet on whether either side used a garbage metaphor. My law clerks are still combing the historical record. But one result of this tension was the Federalists passing the Sedition Act of 1798. In relevant part, that act criminalized speech that criticized the government, Congress, or the president. Violators could be fined and imprisoned. Prosecutions took square aim at the Federalists' political enemies. In the run-up to the 1800 election, Federalists targeted Democratic Republicans and newspaper editors, control the popular media, control the outcome of the election, the thought went, and the Federalists achieved great success. Only one jury ever acquitted a defendant in a Sedition Act trial. But if you know your history, you know that victory was Pyrrhic, because the Federalists were roundly defeated in 1800, and the whole episode was so embarrassing that the party never recovered. And that is far from the only instance of political prosecution in American history. Over a century later, another Sedition Act was passed, this time in response to America's entry into World War I. The Sedition Act of 1918 punished those who uttered, printed, or published criticism of the government in its war effort. And infamously, the government used that act against a presidential candidate, Eugene Debs. Debs had risen to prominence as a union activist, especially after his role in the Pullman strike in 1894. He ran as a presidential candidate in 5 elections, but it was his last one in 1920 that is the most noteworthy. He was bombastic and charismatic. He disdained the intellectual and cowardly political insiders in Washington, D.C., and thought that they did not care about the American people. Naturally, the American political establishment did not like that, least of all the incumbent president, Woodrow Wilson, who prosecuted and convicted Debs under the Sedition Act for a speech in which he criticized the draft. Debs went to prison in the middle of his presidential campaign, and ironically, his best electoral performance came when he was a convicted felon. But Woodrow Wilson called him a traitor to his country and denied him a pardon, and the Supreme Court affirmed Debs's conviction. And that remained law of the land until 1969 in Brandenburg versus Ohio. Now, Brandenburg improved the law, but it did nothing for Debs's presidential campaign. While Lady Justice is blind, law enforcement never has been. It has long been within the prosecutor's discretion to decide whether to prosecute and which charges to file. So long as there's probable cause to believe an offense was committed, a prosecutor can bring a case, which is why everyone in D.C. who jaywalks must beware. Now, on one level, this makes some sense. Prosecutors don't have infinite time and resources. Prosecutors in one jurisdiction might prioritize one crime over another. And while the origins of this discretion are hazy, it dates back to at least the 15th century and the nolle pros procedure in England. But for as long as this has existed, this discretion has coexisted with danger. Robert Jackson, the Attorney General, later Supreme Court Justice, wrote in 1940 that, quote, the most dangerous power of the prosecutor is that he will pick people that he thinks he should get rather than pick the cases that need to be prosecuted. Now, here too, there are questions we can debate. We can debate whether prosecutors have too much power. We can debate limits on prosecutorial discretion. We can debate the propriety of prosecutorial charging decisions, the use or overuse of plea bargaining, the role of the jury, the need of interlocutory appellate review, on and on. But one thing that is beyond reasonable debate is that people should not be prosecuted on the basis of their politics or on the status as a political candidate. Again, from Robert Jackson, with the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. It is in this realm in which the prosecutor picks some person who he dislikes or desires to embarrass, or selects some group of unpopular persons and then looks for an offense, that the greatest danger of abuse of the prosecuting power lies. That is a legal principle, and it is one we should openly embrace. It is my fervent hope that the Federalist Society remains a place of free and open debate, as it always has been, a place where law students and lawyers can come from different points of view in the marketplace of ideas. It is sadly true that such marketplaces are in perilously short supply, in particular on law school campuses. But it is also true that our republic is founded on important legal principles like judicial independence and apolitical prosecutions. Those principles require vigilant protection and rock-ribbed defense. And when it comes to defending those principles, ideation and debate do nothing. Those principles were purchased with blood and sacrifice. So I want you to find a veteran today and say thank you. And then I want you to take a moment and think, given the costs paid by so many to purchase this beautiful republic of ours, what is required of you to defend it? Yes, think and debate, just as we do here every year. Enjoy the freedoms that our Constitution provides, but then stand up and fight to defend them. Thank you.
Thank you, Judge Oldham. We're off to a brilliant start. If I could call, without a break, we're going to begin the first showcase panel. So if I could call the panelists forward, please. And thank you, Judge Oldham. Join me in giving another round of applause for the judge.
Everyone. It's a pleasure to welcome you all to this first panel of the 2024 Lawyers Convention as we celebrate a new home. I think it's fitting that we at least start by looking back. When I first joined the Federalist Society in the 1990s, the landscape was quite different. I think of my father at the time, He was a middle manager in a large aerospace corporation. My father-in-law worked in the same industry as a machinist at a company that manufactured airplane parts. Two jobs in two parts of the same process. But both men lived similar working lives. In that world, if they needed help with their wages, well, they visited the payroll window. Time off for a family problem, it could be handled with a trip to personnel. They would have sipped the same bad coffee from the same silver truck that parked out front in the morning, talking for a minute about the weather, the scores, the kids. Some of the men would have worn a tie, probably the one that they clipped on each day. Others, a Union jacket, the same one that they would wear to services on the weekend. It wasn't a perfect world, of course. Every Rockwell painting has some misplaced brushstrokes, but it was a functioning slice of America with a shared commitment to industry and a common pride in affiliation. These were men who helped build things, and their workplaces mirrored their values. Naturally, the lawyers could not leave things alone. What came next, what regulation wrought, is the subject of today's panel, but the impact, I think, is not much in debate. The factories these men worked in are long gone, paved over for more mixed-use real estate where young professionals are invited by billboards to live, shop, play. The personnel and payroll offices have been shuttered, swallowed into the dark maw of the beast known as human resources. And as Helen Andrews wrote in First Things, the wedge that HR used to shove its way into the American workplace was anti-discrimination law, abolishing, as she writes, every rival system for managing workers by tattling to judges. Judges who were happy to join hands with the managerial class to usher in a new world, supposedly without distinction or difference or divide. The social revolution prophesied by Burnham had arrived. Our elites, as usual, had done their work well. So, it is resolved. We're all miserable, chastened by our foolish pursuit for forced association based on prescribed beliefs and prescribed thoughts. What to do? Is the problem the law or just our interpretation? Our emphasis on identity or an unwillingness to emphasize traditional character? Have we managed too much, too little, or have we just put the wrong people in charge? We are fortunate to have the right people, 5 experienced voices to tackle this topic. Let me now very briefly introduce all of them. Beginning with Jonathan Barry, managing partner at Boyd & Gray. He previously served in the Department of Labor and Department of Justice and as chief counsel to then President-elect Trump's transition. He is a graduate of Yale and Columbia Law and a former clerk to Justice Alito. Heather McDonald is the Thomas W. Smith Fellow at the Manhattan Institute, where she writes on topics including higher education, immigration, policing, and race. She is the author of the bestseller books, The Diversity Delusion and The War on Cops, among others. She is a graduate of Yale, Cambridge, and Stanford Law. Tyler Austin Harper is an assistant professor at Bates College and author of the forthcoming book, The Paranoid Animal. He is also a regular contributor to The Atlantic, The Times, The Post, among others. He is a graduate of Haverford and earned his PhD from NYU. Gail Harriet is a professor at the University of San Diego School of Law, where she teaches and writes on civil rights and employment discrimination. She is the editor of A Dubious Expediency, How Race Preferences Damage Higher Education, a former civil rights counsel to the U.S. Senate Committee on the Judiciary, and currently a member of the United States Commission on Civil Rights. She is a graduate of Northwestern and the University of Chicago's Law School. And finally, Andrew Koppelman is the John Paul Stevens Professor of Law at Northwestern and a professor of political science and philosophy at Northwestern University. He is the author of dozens of books and articles, most recently, Burning Down the House, How Libertarian Philosophy Was Corrupted by Delusion and Greed, and pens a regular column for The Hill. He is a graduate of the University of Chicago and later earned his law degree and a PhD at Yale. In the interest of time, I have done our panelists a great disservice with that very short summary of their accomplishments. Please take a moment after our program to read their fuller bios and links to their works in our program. We will start with remarks from each of our panelists and then move to an open discussion. After what will certainly be a lively exchange, we'll end with your questions. So let's now turn to Jonathan to begin the conversation.
All right. Thank you for that kind introduction, Judge Mady. Because this is a room full of privileged white-collar professionals, I do need to add I am also a white cisgender male with brown hair and a beard, wearing a navy suit and a totally sweet tie and glasses. My pronouns are he, him, and his. And most importantly, we are convening on the ancestral lands of indigenous peoples who voted by a 65-34 margin to re-elect President Donald J. Trump. Now, it is right and just to mock this latest secular liturgy for its absurdity and its overt virtue signaling. But it's more than that. Today, I want to contend that the manufacture and management of group identities serves a more sinister purpose: to make our social environment legible to bureaucratic power. First, to explain this concept of legibility, James Scott's book, Seeing Like a State, gives the perfect example of how legibility leads to power. Medieval rulers struggled to tax peasants in villages where, as was common, no one had a true last name. How could a distant lord even know who was who, let alone how much they could tax each of those people? So Middle Ages rulers forced last names onto lots and lots of villagers. The power to rule was thus augmented by that power to classify, to make legible. We see the same dynamic today, where in an effort to orchestrate socially desirable outcomes, bureaucrats, both public and private, develop very specific classification schemes to segment individuals into group identities. These efforts don't merely flatten the human person, they exert unaccountable and arguably unlawful control over us all. Because this is FedSoc, I want to start with the clear and present danger, the administrative state. It's received wisdom within the conservative movement that civil rights law and its attendant bureaucracy are responsible for the emergence of group identity creating and affirming practices throughout American life. As David Bernstein has ably documented, the administrative state has transformed group identity categories, particularly race, into a comprehensive bureaucratic system and thus able to be acted upon by both governmental and private decision makers. This process followed a raft of mid-century executive orders and then statutory changes prohibiting racial discrimination, and thus required racial categorization to be maximally effective. The most significant and lasting action came in 1977 when the Office of Management and Budget issued its big guidance on this topic. The OMB classification scheme, however, was inevitably, unavoidably an arbitrary one, something the Supreme Court found just last year in the Students for Fair Admissions case, with the majority calling it imprecise and overbroad, plainly overbroad in some contexts and under-inclusive in others. Justice Gorsuch went on to say that OMB's categories, quote, have only become more incoherent with time. But of course, that hasn't stopped the administrative state. The EEOC, for example, has required that employers disclose the racial makeup of their employees since 1966. Note that predates disparate impact. Its mandatory EEO-1 form requires large swaths of employers to submit their workforce demographic data by job category, sex, and race or ethnicity. My old agency, the Department of Labor, similarly requires federal contractors to document race and uses those disclosures to enforce affirmative action policies. all without anything close to clear statutory authorization. And now, I think it is tempting to blame policies like these for the emergence of various practices in the private, and especially the corporate, sphere to elevate particular group identities. And indeed, many public policies encourage just that. But in the beginning, it was not so. The core civil rights protection, the ban on disparate treatment, does not actually require any kind of grouping concept. Laws against race discrimination are enforceable without standardized definitions of races or official designations of which human beings go into which buckets. Instead, disparate treatment restrictions look to the subjective intent of the decision maker, the employer, the landlord, the mortgage lender, and all the law needs to standardize is a generic definition. There's no need for us to hang on to racial categories and their very fraught history. But private corporations not only adopt these unnecessary categories, they propagate them further. For example, there has recently been a drive among big companies to publish their EEO-1 forms, despite no legal pressure to do so, and in fact, a statutory requirement for the EEOC to keep those forms confidential. Why should corporations go beyond what the law requires? Or for another example, the NASDAQ stock exchange has required any company listing on it to disclose publicly the group characteristics of its board members. Now, and this, I'm not making this up, it also required quotas that could be satisfied either racially or by sexual orientation. Portuguese and bisexuals are now fungible. I didn't write it, I challenge it, but I report, you decide. Well, actually, the Fifth Circuit en banc will decide. No law required any of this. So my question is, why is corporate America requiring this? Well, the reality is that these actions are not departures from, but continuations of the historical norm. Frank Dobbin at Harvard has shown that the ever-growing cadre of human resources professionals largely built out discriminatory anti-discrimination practices before the federal government ever cleanly and clearly compelled them to do so. It is true that the likely spark was public, not private. In Griggs in 1971, the court did, of course, expand Title VII liability to cover disparate impact. Congress did not do much to clarify obligations under disparate impact theory, and nor did the EEOC have authority to fill substantive gaps. Corporate executives, for good reason, I think, no longer felt like they understood their legal obligations. Amid that uncertainty, business leaders turned to human resources to develop programs to minimize liability. The HR profession, not satisfied with the payroll office, created new offices to deal with EEO. And they began collecting data on progress towards integration and bias reduction. Dobbin says that these techniques brought dramatic change. By creating constituencies, groups, inside the business who are committed to staying at the cutting edge of anti-discrimination practice, a company's progress towards equity goals became unmoored from, can I say unburdened by, is that C3 compliant, any specific legal requirements. And by using racial classification data as a key part of performance evaluation, managers naturally made decisions on the basis of group identity, especially racial identity, and internalized a group identity conscious attitude. This dynamic helps us see the underlying sociological force behind efforts to classify and manage human beings by these often arbitrary identitarian groups. That force is the group whose identity shall not be named. Well, actually, Judge Mady already did it, but I'm going to do it again. Surprise, it's the professional managerial class. This class lives in the revolving door. The HR professionals who develop DEI initiatives and civil rights bureaucrats on the public sector, they're all the same narrow class of people, and they regularly move across the public-private divide in their own personal career progressions. And their real accountability system is not responsibility to voters or shareholders or workers, but to their own cohort. a lot of what we call virtue signaling is really messaging directed to one's colleagues in the managerial class to shore up one's own status. And because directing the country's push towards increasing minority representation has been part of HR's mission, it attracts people committed to advancing that mission by whatever means necessary. And HR is constantly looking to academics and activists for new things to try to further these new goals. So I think the challenge we face in the age of group identity is properly understood not merely as cultural or even as legal, but as something more fundamental. It is socio-political, the work of a particular social group with its own agenda, its own instruments, and its own authority. How we challenge this group and its DEI and ESG agenda, I think that's a bigger discussion, but the first step is to admit that we have a problem. The human resources blob is part of this professional managerial class that straddles private and public sources of power and that evades traditional mechanisms of accountability like market discipline, shareholder primacy, or electoral control of government. The blob exercises much of its power by putting race and other group identity categories into the spotlight to make those groupings more legible, more salient, more suitable for attracting benefits and burdens. I think it's time we return the favor and throw the spotlight back onto the blob. Thank you.
Thank you, Jonathan. Heather, over to you.
Thank you. Thank you, Jonathan, and nice try with the identity politics. I'm a female. I may be a white female, but I get to trump you on that ground. So the question is, why are we still focused on race and other matters of identity so long after the civil rights statutes purported to take us back towards our founding ideals of a colorblind society? I'm going to argue a little differently from Jonathan, although I completely agree with his structural sociological analysis, but I'm going to talk about something a little more uncomfortable and more core, I think. And the reason we are still doing this is because of the widespread suppression of data like the following. And let me give a trigger warning. I'm going to talk about matters that make ordinary Americans of goodwill very uncomfortable to hear. Ordinarily, racial etiquette would rightly counsel continuing to turn our eyes away from these facts. But frankly, with the left having seized the narrative that it has and implicitly using these facts to tear down meritocracy, sadly, I think we have to go there. And I'm also want to say, I am speaking about group averages, not about any individual. Within any group, there are individuals who outperform their own group average and outperform individuals in other groups, and there's also individuals in groups who underperform, including those of less average performing groups. So, but these are the facts that are not allowed into public discourse. 12% of black 12th graders do not possess even partial mastery, 66% of black 12th graders do not possess even partial mastery of basic 12th grade math skills. A basic score means itself partial mastery of 12th grade math skills, such as reading linear graphs or doing arithmetic. So 66% of black 12th graders do not possess even partial mastery of those basic skills, meaning they possess no mastery at all. 7% of black 12th graders are proficient in 12th grade math, and the numbers who are advanced is too small to show up statistically on a national sample. These are according to the National Assessment of Educational Progress tests. Whites, 4% of 12th graders are advanced, 28% are proficient, 29% are below basic. For Asians, 15% are advanced in 12th grade math skills, 37% are proficient, and 20% are below basic. Now, these are not great numbers for anybody, frankly. they are a national embarrassment across the board, but there are still very large divisions. If you look at the ACT, 6% of black high school seniors are ready for college. 3% are ready for a STEM major. Whites are 5 times as likely to be ready for college as blacks. These gaps never close. The magnitude of them remains, whether you're looking at the LSAT, the GREs, the GMATs, the MCATs, the SATs, they are gaping and they never close. Now, these facts are kept off stage, and here's what the left does. It looks at any given institution, and it says there are not 13% black neuroscientists in working in this this lab to cure Alzheimer's disease. There's not 13% oncologists working in this cancer lab trying to come up with a cure for cancer. The only allowable explanation for that lack of proportional representation is discrimination. Somewhere along the line, there's systemic racism that is keeping out qualified black applicants that would, if they were not discriminated against, would result in 13% proportional representation. Colleges, bizarrely, I mean, you hear, frankly, all the time, the New York Times talks about when it addresses racial issues and racial proportionality, it will always say, well, blacks are being excluded from college. Well, anybody who knows anything about college admissions knows the opposite is the case, that there is a vast black privilege working when it comes to college admissions and to hiring and promotions. But even college presidents cop to this phony narrative that, well, somehow we're discriminating. You had Christopher Eisgruber famously in the waning years of Trump 1, when Trump finally got his act together and said to Christopher Eisgruber, so you're saying Princeton is racist? Well, we're going to take you up on that, and we're going to sue you for systemic discrimination. So these college presidents and everybody within them would rather cop to phantom racism than speak honestly about the skills gap that stands in the way of proportional representation in our meritocratic institutions. Colleges admit students that are not competitively qualified. They do put this unbelievable handicap on black students by making them the one group that are systemically catapulted into academic environments for which they're not competitively qualified. No opponent of racial preferences, such as myself, would ever say that blacks should not go to college. Of course not. All we're saying is they should go to college under the same conditions as everybody else, which is with a peer group that matches their academic skills. So blacks face this handicap of being put into colleges with a peer group of whites and Asians that have about a 200-point SAT gap. Understandably, predictably, through no fault of their own, they struggle. Enter the DEI bureaucracy that comes in with the narrative that the reason you are not doing well in college, the reason you don't feel at ease, that you feel out of place, is systemic racism. You are the victim of ongoing racism in this institution. And you have these bizarre little psychodramas played out between a willing audience of DEI bureaucrats and these narcissistic students who go around claiming that they're victims and that they're unsafe. And the students act out their psychodrama's oppression, and the DEI bureaucrats say, you're right, what we need is more DEI bureaucrats to ease your way into this white institution. We saw this most classically at Stanford Law School with the meltdown when Judge Kyle Duncan came, and we had Stanford's DEI bureaucrat Tyree Steinbeck step in as the lead voice for Stanford. It wasn't Jenny Martinez, it wasn't the president of Stanford University, to ask Kyle Duncan, is the juice worth the squeeze? Is the juice worth the squeeze of you showing up and traumatizing our Stanford law students because of your writings as a private citizen on the issue of gender ideology? So the DEI bureaucrats, yes, they do control the discourse within universities, but sadly, I do not think that it is going to be possible to dethrone them, which they absolutely should be, as long as the left can continue saying that resulting disparities of a meritocratic system is because of racism. And in our fanatical and terrified efforts to continue changing the conversation, you have American civilization and Western civilization itself turning on its greatest accomplishments. You have the head of the National Institutes for Health, the last head, Francis Collins, saying that science is racist, that his institution is systemically racist. He has counseled against his fellow biochemists and fellow bioscientists from attending Manels. Do we know what Manels are in this room? How deeply are you guys into the academic blog? Well, a Manel is a panel that doesn't contain sufficient females or other underrepresented people. So Collins is saying, I'm boycotting any Manels in neuroscience. So we are saying that math is racist, that science is racist, that objectivity is racist. You had the Smithsonian Institution during the year of the George Floyd mass psychosis, posting on its website that objectivity and a passion for accuracy are racist. We keep changing the subject. What we have to do is a legal matter, obviously. Trump didn't do this the first time around. He has got to set his lawyers on the code of federal regulations and extirpate every single disparate impact regulation in there that is within the capacity of the executive to get rid of on its own. Congress has to step up, it has to go back to those statutes, exercise its legitimate power, do not hand it off to the bureaucracy, remake those statutes in the name of colorblindness, return to the equal protection standard of intentional discrimination, get rid of disparate impact. It is going to tear us down into a swamp of mediocrity that we are never going to recover from. Thank you for your attention.
Heather, thank you. Tyler. It's a pleasure to be here with you this morning. I will confess that I am not a lawyer, and I have a worse confession, which is that I am a Bernie Sanders Democrat. So being invited to the Federalist Society is a bit like being invited to the Lion's Den for supper. Thank you. Might be the last clapping you do, so I appreciate it. So at any rate, it's not clear if I'm on a panel or on the menu, but I am here. And so I'm sitting here in part because as a journalist, I've often written about the problem of identity politics in American life. I am one of the many members of the chattering class who lodges complaints and gets in culture wars over identity politics and DEI and what gets called wokeness. And so what this means is that even though I am one of these Bernie Sanders Democrats, when it comes to these identity politics issues, I sometimes end up on the same side of the conversation as conservatives, but generally for very different reasons. And that's what I'd like to discuss in my opening remarks today. So it's clear to me that when we talk about identity politics and when we have these culture war debates over the place of identity politics in American life, on both sides of the aisle, one identity really gets left out, and that is identity related to socioeconomic status or class, right? Talking about identity in America is almost always about race, gender, or culture, and it's a way of not talking about class, socioeconomic status, or talking about labor. So here's a stark example that I think illustrates why I am one of these people on the left that's critical of some of the developments under discussion. We think of American colleges and universities, the sort of places many of us teach at, as the epicenter of identity politics in American life, as the hotbed of wokeness, as it were. And I think most of us can agree that over the last decade, that identity politic trend has really exploded on American colleges and universities. Now, here's a remarkable fact about that. Over the last 10 years, as American colleges and universities have become increasingly focused on identity, and particularly social justice initiatives related to identity. At the same time that this identity fixation has exploded, tuition has also gone through the roof, and the number of tenure-track employees in American colleges and universities has shot downward as more and more academics are employed as gig laborers, the sort of academic equivalent of Uber drivers, often without health care, often with expansive teaching loads. So in other words, as universities have become more fixated on justice and identity, they have also become more economically exploitative, more predatory, and have eroded labor protections in the university. And my argument is that this is not an irony, right? These facts are not in tension. This is not a bug, but in fact by design. Because what this focus on identity does is distract from the financial model of American colleges and universities, which at this point are hedge funds with a hospital system and occasionally an academic institution attached to them. And so I think it's really important for us to see that this economic exploitation, the tuition increases, the fact that your children, if you have children in college, are often being taught by people who don't have health care, these two things are related. They're two sides of the same coin. So I've said that I identify as a leftist, and I think it's important to clarify what I mean by leftist first. And I will thank Jonathan Barry for giving the land acknowledgement. So I think I'm contractually obligated to as a liberal, but he did it for me, so I'll spare you. But when I say I identify as a leftist, we use these phrases interchangeably: progressive or far left or liberal. And the terms are slippery and they're not really helpful. But for me, when I say I'm a leftist, I mean that I believe that economic inequality and economic exploitation is the primary problem in American society, and that it has got worse over the course of the 20th and 21st century. And the problem today, really in the last decade, and especially since 2020, when people invoke the left, and particularly when they say the far left, they don't necessarily have people like me who are primarily worried about economic problems in mind. They have this new cultural or identity left at the forefront of their imagination. These are people that I think of as belonging to what I call the multicultural managerial class or the multiracial professional class, right? This is the highly educated part of the left for whom ideas about identity and equity have really come to the forefront. Now, for this crowd, unlike for me, economic inequality for this crowd is often not the problem. The problem is disproportionate economic inequality, economic inequality that is not evenly distributed along lines of race and gender. So since 1978, CEO pay has increased by 1,200%, while worker pay has increased between 15 and 24%. That's a 200-to-1 rate. I do not think over the last 40 years that CEOs have done a 200-time better job at their work than workers, but what do I know? But in the eyes of identity progressives, as long as 50% of CEOs are women, 19% are Hispanic, and 13% are black, reflecting the US population, then this is all fine. And I like to joke that for the identity corner of the left, economic inequality is okay as long as the demographically appropriate percentage of blacks work at BlackRock. The problem with this vision is that if you are not one of those blacks at BlackRock, if you are not a CEO, if your pay is continuing to stagnate like the rest of American workers, then this supposed vision of racial justice doesn't do you very much good. It probably does not matter to you the percentage of folks on Wall Street who are black or Hispanic if you're an American worker. Now, here's the thing. Since around 2014, 2015, whenever you want to date the start of our increasing identity fixation on the left, definitely since 2020, these identity issues have been on the driver's seat, and I think not just on the left, in different ways on both sides of the aisle. Most of our political fights have been culture war fights over identity. And we failed to notice and indeed ask who these fights benefit, right? Who does it benefit when we are overwhelmingly having arguments again and again about issues related to group identity? Who benefits when we are spending all of our energy debating pronouns or racial sensitivity training or whether or not immigration immigrants in Ohio ate a cat, which they did not, for the record. But who benefits from these identity-based culture wars? And the people who benefit are the people who benefit from our economic status quo remaining the same and who would like to see it remain the same. The journalist Ezra Klein recently argued that the Democrats, my side of the aisle, are in the middle of a spiritual crisis because it has lost not just the working class, but the multiracial working class, the multicultural working class. Democrats say, right, that the Democratic Party is for this working class. It's for the multiracial working class. And again, we have this remarkable fact that the multiracial working class does not seem to agree with them, right? And I think this is partly due to some cultural conflicts. It is simply true that on the whole, minorities tend to be more conservative on a variety of social issues than Democrats. But I do not think that's the only issue here. I think we exist in a time of ideological disorder that really stretches to the middle of the 20th century. This is a caricature, but generally speaking, the right has tended to be more libertarian on economic issues and has generally not favored any limits to the market while they've embraced traditionalism, right? This gets called fusionism in the mid-20th century. So the right embraces no limits on markets, a kind of libertarian economic status quo, but embraces limits on social and cultural life. On the other hand, the left has the kind of mirror image, which we are more willing to embrace limits on markets, not as much as I would like, but nonetheless, some of us are at least. But at the same time, we are much more reluctant to impose any limits or norms or around these social and cultural issues. And so we have kind of split the libertarian baby across two parties. And the issue here is that neither of these parties have really managed to speak for the working class or the multiracial working class, which tends to be both more economically populist. The working class is on the whole more supportive of social programs and New Deal style initiatives, but also more socially moderate. And to date, both parties have really tried to win over this group, not by attending to their economic needs, but rather by engaging in these cultural appeals and culture war. So the right tries to win working class minorities by saying the left is too woke. The left tries to win working class minorities by saying the right is too racist. And my point is that both of these arguments are a distraction that leave that fundamental economic status quo, the problem of inequality in American life, they leave that unchallenged, right? The fog of war produced by our culture wars obscure the economic reality underneath. And so this is how I think we should think about these debates. And in fact, these kind of identity discussions and panels that we're having is that culture war debates over identity politics are lipstick on the pig of economic exploitation. To the woke, the lipstick is blue, and the anti-woke lipstick is red, but the function is the same in both cases, right? That culture war, identity wars exist to distract from the immiseration of American workers. And what I would add to all of you is this does not just include the laboring masses. This includes people in the professional class. This might not, most of us, I think, are in the professional managerial class, right? The archetypal professions for that class are doctors and lawyers and journalists and academics, right? And although I imagine this is not true of everyone in this room, as a whole, those professional classes are on the decline, right? They are actually downwardly mobile. That might not apply to most of us, but it is true. Doctor pay has declined. Lawyers are having a harder time paying back their loans. Like I said, academic labor has been gigified. And so the message I would leave you with is that as these trends continue, as the working class becomes more immiserated, and as the professional class becomes more downwardly mobile, I think at a certain point we're going to have to decide, those of us in the professional class, where our loyalties lie. Do they lie up or do they lie down? And to me, that is the fundamental challenge. I think we need a new economic status quo. I think it needs to be bipartisan. That's why I'm here. And you know, I think for many people, they'll say that sounds insane, right? We can't get the left and right to agree on the economy. And to you, I would say the left and right have agreed on the economy for 30 years. Neoliberalism has been the status quo, so I simply don't believe we can't have a new one. Thank you so much.
Good morning, ladies and gentlemen. You know, we began passing federal anti-discrimination laws 60 years ago. And these laws were intended to make our destinies depend less on race, sex, and ethnicity. And in many ways, they've actually been very successful. And yet, Today, 60 years later, it seems all anybody can talk about is race, sex, and ethnicity. They drive just about every issue of public policy. So the obvious question is, what happened? The basic point I want to make here, and I think it follows on from some of the things that Jonathan said, is that some of this has been brought on in part because of law rather than in spite of it. Over the years, legislators, judges, bureaucrats have been adding incentive upon incentive for the growth of group identity on top of the basic anti-discrimination laws passed in the 1960s. That has had an effect. Today, I want to talk mostly about a very specific structural add-on to Title VII that I believed moved us in the direction of our current race, sex, and ethnicity obsessions, and that is the Civil Rights Act of 1991, nobody's favorite Civil Rights Act. It's just an example, but I think it's a rather big example. You know, if you want to know why we walk on eggshells these days, the 91 Act is certainly a prominent part of all of that. But before I get to it, let me just make what I think is an obvious point, and that is that all anti-discrimination laws have at least some tendency to fuel group identification. We all know that when a hammer is your only tool, every problem starts to look like a nail. Well, the law is a tool. If your client is desperate because he's been fired from his job and he can blame it on race, sex, or ethnicity, you can help him. He's got a case. But if the real reason is just as arbitrary, maybe even sillier, the boss was just jealous of his good looks, you can't help him. Consciously or unconsciously, that's going to affect how people see things. The way I like to put it is that anti-discrimination laws have an undertow. Their main effect, God willing, is to discourage discrimination, and that's all to the good. But there's also a drawing back, an undertow, in that employees now have an incentive to see things in terms of those identity factors. Almost by accident, Congress constructed the original Title VII so that the undertow would be weak. The original version had limited remedies. A plaintiff alleging a violation could hope to get only two things: lost wages or an injunction. There was no recovery for emotional distress, no punitive damages in the original Title VII. Weirdly, Congress put that limitation there to make sure that Title VII defendants, particularly in the Deep South, would not have the right to a jury trial. They wanted remedies that would be equitable in nature, and they knew that the Seventh Amendment would therefore not apply. They didn't trust juries, to be fair, and frankly, they were probably right about that at the time. When it turned out, you know, the way it turned out, these limited remedies worked tolerably well for other reasons as well. Within a few years, the law of harassment was developing, first with race and later with sex. You know, and in some respects, you can understand how this is happening, how it happened at the time. It was obvious that you can't have a situation where an employer can dress up in KKK robes and scare the daylights out of an African-American employee and still say, yeah, but we hired this person in compliance with Title VII, we're okay. You know, there was going to be the development of harassment law. That was just gonna happen. So during this early period, before the 91 Act, the largest sum of money that a plaintiff could receive would be winning lost wages. They wouldn't be able to get emotional distress damages. They wouldn't be able to get, punitive damages. And therefore, the fact that harassment law necessarily developed and necessarily was vague, extremely vague, frighteningly vague, In those situations, you could figure that really the only cases that were going to be litigated would be the cases that involved either lost wages, and those are going to be the really bad cases, or where the plaintiff actually wanted an injunction, and that's not really going to be the remedy that most people are looking for in these cases. And so it was okay. It was working tolerably well. When the 91 Act kicked in, it gave plaintiffs the ability to collect emotional distress damages as well as punitive damages. To be sure, there were caps on this under the statute. The most that a large business would have to pay was $300,000, less for a small business. But that turned out to be more than enough for the number of claims to skyrocket and for employers to panic. In some sense, of course, that is exactly what the Act's supporters wanted. They wanted more lawsuits, higher damages. They wanted what they thought would be more effective deterrents. What they probably didn't bargain for was how overwhelming the deterrent effect would be. And the most fundamental reason for that disproportionate deterrent effect, was the cumulative nature of harassment as it was articulated in the courts. So as the law defined it, 1,000 pinpricks, no one of which was serious in itself, could add up to a violation of Title VII. They wouldn't have to come, those pinpricks wouldn't have to come from the same person. A sexual harassment case could be made up of such things as a rude remark from one employee, an annoying stare from another one. Somebody pins a sexy cartoon on the bulletin board anonymously. Same with race. One employee's objection to affirmative action plan, another employee's imprudent race-based tease. It all adds up. Individually, those pinpricks would have no legal effect, but together, at some ill-defined tipping point, they would create legal liability. So once the 91 Act goes into effect, jittery employers correctly understand that to avoid liability, they need to control employee conduct at the pinprick level. There's no other way. It just can't be done otherwise. Employers could hardly instruct their employees that what you have to do is wait to see whether your colleagues might be causing potential offense, and if they are, dial back your own conduct. So zero tolerance rules start coming up all over the place. Hapless employees have to learn to grin and bear all the efforts to control their day-to-day interactions with other employees. What would have been considered officious micromanagement prior to the 91 Act would henceforth be understood as standard business practice. As the number of EEOC claims exploded, diversity and sexual harassment training became ubiquitous. Supreme Court decisions in the 1990s gave employers a little bit of an advantage if they could prove that they were trying hard to prevent harassment. So only a very stupid employer would fail to get the message. Bring in the trainers, bring in more trainers, have them come in every year. No, have them come in every 6 months. Well, maybe we need it every 3 months. Bring on the DEI offices. If you've only got one person in that office, well, maybe we need 2. Maybe we need 15. Training soon became a billion-dollar industry. So if you want to know something, about the concept of microaggressions, why did that become so popular? This is how. The businesses that offer training, they need to keep themselves relevant. So they need to persuade their customers, that is the employers, that they have specialized knowledge, that they really know what is offensive and what isn't. So the message is, you may think that your employees know how to be polite, know how to be professional, but we have the inside dope on all the things that women and minorities really find offensive. It's a lot more than you think, they'll tell you. So the result was offense inflation. We even got, we got trainers saying you don't want to talk about a company picnic because picnic is an offensive word. Meanwhile, the doctrine of retaliation in connection with Title VII, which made a lot of sense when courts started saying, you know, you can't possibly live in a world where if someone makes a Title VII claim, that you can punish them for that. But in the era where harassment is the usual cause of action, this causes no end of problems. You know, once somebody makes a complaint, even one that everyone in the office knows is silly, they are essentially untouchable. You can't even stop inviting them to the Thursday night poker game. Instead, it's the hapless guy who's being wrongly accused of harassment. He's the one who can be cut out of the poker game. He's the one who can be transferred to the company's Siberian office. So I have actually tons more to say about the various ways in which the law actually has encouraged the world that we live in today, but the Federalist Society is a stern taskmaster, so I'm only allowed to speak for 9 minutes, and I think I'm at like 8 and 59 seconds. So I'm hoping for questions. So, thank you.
All right, this panel is about why group identity is so salient today, and I'm going to talk about an answer that's just been published in a good book by a sociologist, and I'm going to push his analysis to conclusions that are my own and not his. Federalist panels typically have a token lefty. I'm astounded to discover there are 2 of us here today. Good for you, Federalist Society. I do notice, though, we're both liberals. I mean, even, as Tyler identifies as a Bernie Sanders Democrat, but he's basically a liberal. And I think if you wanted somebody to defend woke identity politics, you really should have gotten a progressive, because I'm not that guy, and neither is Tyler. I am going to speak, though, on behalf of one particular group identity that ought to unite members of our tribe in this room as educated professionals with distinctive competences. And I think that that is in tension with certain partisan identities on both the left and the right. So the book I'm going to talk about is a new one by Musa Al-Gharbi. It's called We Have Never Been Woke, The Cultural Contradictions of a New Elite. It is a shrewd history and analysis of the performative politics we see today. Its primary focus is the leftism that now dominates the Democratic Party, although, as I'll shortly explain, the pathology it describes is not only a problem for the left. This cluster of political positions and communicative moves that are called wokeness is often alien to the people who it claims to represent. Most Black Americans don't want to defund the police. Almost no Hispanics identify themselves as Latinx. The people who are genuinely vulnerable don't talk about themselves in these ways. And this way of talking clearly helped Trump win re-election. And norms of this sort are predominant among white, educated knowledge workers who produce and interpret data and tend to be highly compensated professionals, doctors, educators, journalists, financiers, and lawyers who deploy such discourse. Jonathan Berry said this as a form of virtue signaling and status competition among themselves with little or no benefit to the disadvantaged communities they purport to represent. The book's valid and revealing, but Al-Gharbi is a sociologist. He's not a political philosopher. And because his task is descriptive, not normative, he never names the deepest cultural contradiction in the phenomenon he describes. The knowledge class justifies its privileges. He doesn't say this, but it really does justify them by the results it delivers, but it increasingly concerns itself with symbolism rather than results. And that fact points toward a remedy which I think could ameliorate the worst tendencies that he describes. Now, this is a phenomenon that's confined to what he calls symbolic capitalists, professionals who traffic in symbols and rhetoric, images and narratives, data and analysis, ideas and abstraction, as opposed to workers engaged in manual forms of labor like goods and services. Well, this is us. We're lawyers, right? This type of performativity happens during periods when members of the class are in competition with one another for status, which happens from time to time in American history. He worries about inequality. Tyler worries about inequality. I think inequality is inevitable in any society. It's certainly inevitable in a capitalist economy. The interesting question is under what circumstances it's justified. There's also an issue of magnitude where I think I am closer to Tyler. The philosopher John Rawls, I'm allowed to say his name here, offers a crucial insight. Inequalities are justified to everyone in society if they operate to the benefit of the least advantaged. This is an important justification for capitalism. Capitalism has nearly eradicated world poverty. But it also has specific implication for the symbolic capitalists. The emergence of the professional classes benefited everyone. The standard of living of even the poorest rose because of their expertise. The obvious example is the medical profession. It's a path to wealth, but it also prolonged everyone's life, including the poorest people. By 1900, the doctors were powerful enough that they could induce some states to force everyone to be vaccinated against smallpox. And you know what happened then? Smallpox disappeared. Al-Gharbi's book never poses the Rawlsian question. He tends to emphasize the elitist and parochial self-serving character of the symbolic capitalists' claims. But the benefits of having that class are hard to separate from the privilege. If people are going to be asked to defer earnings for the sake of higher education, they'd best be compensated for it. And if it's okay for business people to like money, then it's got to be okay for the symbolic capitalists as well, although we don't like to talk about it as much. Maybe the Federalist Society is different. The real question is whether they're worth what they're paid. They are worth it, but only if they do their jobs. And this is the real problem with wokeness. It's impairing the capacity of symbolic capitalist institutions to do what they're paid to do. The hallmark of all the professions is instrumental rationality, delivering results. Medicine reduces morbidity and mortality. College education produces people who know how to engage with ideas and arguments. Science and technology produce the capacity to control natural processes. Competent finance and business management have made America rich. But wokeness is not about results. It's a collection of performative gestures, and the gestures are blunting our useful skills, our capacity to accurately understand and adequately address these problems. The pathologies that Heather talked about are stark examples of this. And awakenings tend to produce diminished popular trust in expertise. The symbolic capitalists today are less trusted because they've become less trustworthy. Universities have become left-wing monocultures. Mainstream journalists are more inclined to spin the news in a way that conforms to leftist priors. Even science and medicine are now self-censoring to prevent the dissemination of facts that are inconsistent with dominant left narratives. But this performative virtue signaling is not exclusively a phenomenon of the left. The right has its own varieties of destructive symbolism. Al-Gharbi observes there are entrepreneurs of anti-wokeness who behave as if condemning, mocking, or deriding wokeness somehow obviates the need for further action on their part in pursuit of the social justice goals that they ostensibly endorse. And the right today has propositions that the tribe demands that you publicly endorse and even persuade yourself of. So even though competent analysis shows them to be poppycock. So there's one writer reflecting on his youth recalls, I'm quoting here, tax breaks and social security cuts were socially acceptable ways to be conservative among the American elite. I am, of course, quoting J.D. Vance. One sends a similar signal by denying that there are ever medically necessary abortions, and the next frontier of counter-wokeness seems to be vaccine skepticism. And the most destructive example is climate change denial. Can you imagine what the world would be like if we'd enacted a Hayekian carbon tax in the 1990s? Wokeness is smug and irritating, but it hasn't inflicted anything like the level of destruction and misery that this delusion has produced and will produce. The ideal of professional integrity and effectiveness ought to unite symbolic capitalists on the left and the right because zealots on both sides imperil our missions. The promise of symbolic capitalists can be realized if they operate in political alliance with the people who we purport to be benefiting, the working class, ordinary Americans who are not members of the symbolic class, are comparative advantages that we can genuinely improve lives. Wokeness has created opportunities for the Republican Party because wokeness drives working class voters away from the Democrats. Tyler is right about this, too. But the Republicans are going to blow their chance if all they can offer is their own variety of performativity. Right now, their program is dismantling restraints on pollution and fraud, together with tax cuts, high tariffs, and immigration restrictions. Economists will tell you this is not the way to raise wages, but the economists are increasingly marginalized in the party. I'm going to end with some Marxist terminology. The reality-based community is a class in itself. It needs to become a class for itself. Thank you.
Thanks to all for those remarks. So let's begin the discussion by picking up on something that has come up in each of the commentary, and that is the suggestion that the current state of our design is the current state of our elite, right? And if that's the case, then who exactly should take over? For instance, is meritocracy still the right alternative to identity classifications?
So for my part, I think this has been acknowledged across the panel that class distinctions, like in the existence of some kind of elite, is inevitable, and it's not necessary. It's not a good or a bad thing. It's a fact of life. The challenge is having a leadership cadre that has focus on actual virtue and not on virtue signaling. So Judge Mady mentioned the author Helen Andrews. She has an earlier essay called, I believe it's called Against Meritocracy, where she talks about one of the problems with the kind of the founding myth of meritocracy is that it allows people who have achieved high measures of wealth and status to tell themselves, I got here on my own merit, and if people aren't in the same place as I, it's because they're somehow less deserving, and I don't have reciprocal obligations. I don't have the noblesse oblige characteristic of earlier, more overt aristocratic societies to be able to be of real service. So I think that concept of merit and excellence, those are very real. But I want to suggest that other sources of group identities that we haven't talked about are places that could be potentially healthier. Group identity that is grounded in family, in place, in community. These are things we don't have time to go deep into today, obviously. These are things that get disturbed and uprooted by our national credentialing system, which exists in many respects to strip mine human talent from across the country and concentrate it in like 5 hub cities, including this one. So that's the beginning of an answer, but that's you asked.
I would say to the question, is meritocracy the solution? Hell yes. It is the only solution that will allow civilization to continue flourishing. There should be no compromise on excellence. We should recognize that there are objective distinctions of skills. Some people can do physics better than others. This is not the judgment is not an epiphenomenon of some kind of oppressor state. And if it is the case, as Jonathan and others have suggested, that there are a generational transfer of a certain degree of privilege that allows certain people maybe to better exploit their own natural capacities, the solution to that is not to tear down the standards. The solution lies elsewhere. And this is the reason why I am not in favor of the socioeconomic status alternative to racial preferences that have even, I think, the SFFA suit, one of its experts, the guy that's always promoting this, wants to advance, because you are never doing anybody any favors, on average, by putting them into an environment for which they are not competitively qualified? Will there be the diamond in the rough who is discovered and is admitted with SATs of a standard deviation below and manages to flourish? Yes, that can happen, but the average is not good. So you keep the standards, and if we are worried about accumulations of socioeconomic privilege, use other means for spreading those privileges around, but do not compromise on what it means to do good science, on what it means to be a good judge. It is terrifying, the Biden record on judicial nominees that was based overwhelmingly on identity politics. The quality of our jurisprudence matters. It matters to our public ideals. Do we have coherent explanations of our founding principles? It matters to commercial matters as well. Private parties have to be able to understand, predict what the law will do, and to start putting people into our federal bench on the basis of their identity, not on the basis of their judicial competence. These issues are difficult. Every time I read a Supreme Court opinion, I say, whoa, this is not something for the faint of heart or the feeble-minded. So we have to unapologetically defend the idea that excellence matters, and you can spot it.
So I will quote the great philosopher Mike Tomlin of the Pittsburgh Steelers that the standard is the standard. And I agree with that. I think the open question, though, when we want to talk about meritocracy, and I agree a meritocracy is an ideal worth striving for, all of the ways in which the material conditions of our society don't lend themselves well to meritocracy. When I was in grad school, I was a college admissions tutor in Queens, and one of the things I found very rapidly was that my Asian students I worked with often had sterling SAT scores, 1 million extracurriculars, and they were also often poor. I tutored in a part of Queens that was not especially wealthy. These were the kids of dry cleaners and people who were cooks at Chinese restaurants. And yet, they still had a terribly hard time getting into college. While wealthy white clients I worked with in Manhattan, close to NYU, often who had legacy connections at universities, soared into those same kinds of institutions. So I agree that meritocracy is an ideal worth defending. I agree that standards are worth defending, and we don't do favors when we lower them. And yet, at the same time, I think it's important to be aware of the many, many barriers that we are blind to when it comes to actually approximating a meritocracy. And I think that will always be an approximation. Obviously, there are always facts of life that will give some people a leg up and not others. But there are a great deal of material facts, particularly in the American university system, that I think militate against meritocracy. And I have taught over the last 10 years enough kids shot out of prep schools like a cannon to know that despite, as grade inflation soars, it's not always as easy. Talent isn't reflected on the CV and the grade point average in ways that we might think. So I think we need to be open to challenging some of those ideas. I agree we should defend meritocracy, but I also think we need to recognize what are some of the real barriers to it that are under-examined.
I want to comment just on higher education for a second here, where, there are a lot of different issues here. When it comes to STEM schools, I want a relentless, unforgiving meritocracy. I don't see how we can have anything other than that. But I sure would like to see colleges and universities, I want to use a word here that I don't always use, the D word, diversity. I would like to see universities that are built on different sorts of bases. U.S. News ranks schools. You can go to the #1 school, you can go to the #2 school, and God forbid that you have to go to the number 43 school or the number 107th. It shows that you're not really as good a person. No, I want to see different kinds of universities with very different sorts of things in mind. I'm a product of the University of Chicago, where, academic freedom and let it all hang out, let's debate everything. That's the University of Chicago. But why can't there be a university that says what we try to do is produce, ladies and gentlemen, where we actually are not, we don't let it all hang out. We want people to be much more civilized and never be offensive. Let them have their school that isn't offensive. I want to be like at a school like the University of Chicago, where it's like, let's debate everything. But not everybody wants that, and there's room in the world for the school that wants to be, we're trying to produce good Christians. We're trying to produce good Jews. We're trying to produce people who are particularly interested in the environment. We're trying to, provide a school that is especially for people who are interested in being multilingual. Whatever it happens to be, we don't seem to have that now. What we have instead is just a fake meritocracy, where U.S. News tells us which are the best schools, and in fact, they're depending upon their history over a long period of time for this notion that, hey, we're the meritocratic school. They're often not, but we can have different kinds of schools, and it doesn't have to be numbered from 1 to 150.
Well, I'll just briefly say, since Tyler and I are the tag team on the left, I need to say something on behalf of flat-out redistribution of wealth, which is instantiated, for example, by, let's see if you keep hissing, free elementary school for every child in the United States, whether their parents can afford to pay for it or not. A radical innovation of the last 100 years. The hissing stopped. What happened? So two big changes that have happened in the last 50 years. One is that states have stopped subsidizing their state universities, and so state university tuition is now really expensive. It didn't used to be. That's a blow to meritocracy, because it means that there are some people who used to be able to afford to send their kids to college, and now they can't. And the other is the shift in financial aid from need-based to merit-based financial aid. And really started around 1980. So I'm also a University of Chicago graduate, and I was very lucky. I was smart enough to graduate in 1979. Today, I graduated, parents absolutely broke, graduated with $5,000 of debt at what, like 3%, some ridiculous thing like that. And I think that if I were to apply today, I would have to yield my spot to somebody richer and dumber. That's not meritocracy. Lower tuition for state universities and more need-based financial aids are indispensable components of meritocracy. We haven't got them now. We used to do better.
I just want to add, I completely agree with that. And what I find so amazing about the college loan tuition discourse is that it holds colleges harmless. We all talk about rising tuitions as if it was this naturally occurring phenomenon, and everybody's saying, okay, we need more college loans or less, whatever. And the colleges, meanwhile, are saying, nothing going on here. The tuitions are a function of what we've been talking about today, which is the rising bureaucracy. Yes, the DEI bureaucracy, but it's more than that. The DEI is a subset of student services. And I look at the Chronicle of Higher Education Daily Bulletin, and they've got a comings and goings section. And sadly, colleges are still hiring DEI bureaucrats. You'd think it's all over, but it's not. There's still the dance of the lemons. But there's these other functions that are just remarkable, the retention specialists and the vice presidents of student belonging and all of this. And it's just amazing. And so these colleges have to be held to account. They are the reason that tuitions are rising, and the taxpayers should not bail them out unless they can get their act together.
All right, so picking up on that point then, what does the crane look like, and who is steering the wrecking ball, right? By one estimate that I saw, DEI spending in corporation is going to hit $15.4 billion by 2026. I would speculate that there's lots of nonprofits that are not making profit in this area too. So what is change going to look like, and where is it going to come from?
And I would, echo something that others have said, which is that I feel like we need different kinds of universities, and we need universities that are diversified in their intent. I would agree with the problem of administrative bloat and the sort of ever-expanding DEI bureaucracy. I'm very much not a libertarian, but when it comes to academic administration, I sound very quickly like a libertarian. I think we need a couple professors and the librarians, and I'm not sure what else we need in universities. But it's not just administrative bloat. There's also the problem that colleges and universities, as I like to joke, have become luxury resort experience centers where they have lazy rivers at LSU. I don't know why we need that. And so I think part of the problem is that colleges and universities are in an entertainment arms race to become these luxury places where students can come and hang out for 4 years and then sometimes go to class. And I think that is a cultural problem that we need fixed. And I refuse to believe there are working people and people who don't want to pay on an arm and a leg for college tuition. I refuse to believe that there are not Americans in this country and there are not kids in this country who would happily go to a university that does not have the lazy river, that just focuses on academics, that does not have the ballooning administrative bureaucracy that we have, and would get tuition down. So I think it's not just about the hard problem of bureaucracy, it's also about the cultural problem of expectations students and parents have for what their college experience should look like, because that is driving costs too.
So one more crane and one more wrecking ball, I think results from really like a lot of people in this room and who you represent, which is to say that the conservative legal movement in particular has been getting much more comfortable getting serious about enforcing anti-discrimination law, including against private entities like employers, like universities. I think the tip of the spear on this in recent years has been the organization America First Legal. They've done a tremendous amount in this regard. And I used to just be able to point to them, but it looks like President-elect Trump has just hired their founder to be his deputy chief of staff. So it may be, I have no inside information, but it may be that the call might start coming from inside the House, and that EEOC and DOJ civil rights may well get a lot more serious about enforcing our colorblind laws.
Also, just sheer political power. What the red state governors were doing with DeSantis and Abbott, just saying, we're not using state taxpayer dollars to fund the DEI bureaucrats. And so, of course, everybody began changing their titles to, deans of equitable outcomes or something. I don't know, but that, they are chameleons and will try to hold on to power. But, and this gets into the very difficult topic of academic freedom, and some of the measures may have gone too far, at least with regards to college. I think it's within the prerogative of political leaders to say for K through 12, we want a curriculum that places due emphasis on American greatness as well as its flaws. There's no risk now that we're not going to focus on the grotesque hypocrisy of American history and our centuries-long gratuitous nastiness towards blacks. That is taken care of, but we need to course correct a little bit. But when it comes to college control, the professors, excuse me, start screaming like, angry pigs around. They can't touch us, you can't touch us. I'm ambivalent about that, but I think there's a lot that the state governments at least can do to say, at least with regards to the bureaucracy, we want you to be much, much leaner and meaner, and otherwise you're not getting more taxpayer dollars.
Are we comfortable with that solution? Is more regulation, is more governmental enforcement, which sometimes is called governmental intrusion on private power, a comfortable response to the problem? I've stumped them.
I will say, as the Bernie Sanders guy, I will say, yeah, I am comfortable with government responses to problems. So, I would say one thing that's really important,
That's dog bites man.
We have, We talk a lot about diversity, but I think, a complaint that comes from the other side of the aisle to mine a lot is the lack of ideological diversity. And I think one of the drivers of the lack of ideological diversity is what I mentioned earlier, which is that declining tenure rates. People do not have tenure protections to say what they think. And so I think if the government is going to be pumping money into state colleges and universities, and I think they should be, I also think I agree with the question that there should be leaner administration and bureaucracy. I think there should be more oversight into why are we having lazy rivers at universities that are public. But I also think there should be basic standards for what % of faculty have tenure or on the tenure track. Because as was mentioned with judges earlier, one of the things that tenure does is protect faculty politically. And giving professors more money and more job security might not be popular in this room, I don't know, but I do think it's a precondition for having more political diversity on campus. And I would also add that I don't think it's a coincidence that if you look at graphs about the decline of tenure-track faculty, and then if you want to think about the rise of identity politics and wokeness and so on and so forth, and the decline of ideological diversity over that same time period, those graphs are related for a reason, right? One is going up and the other is going down. So yeah, I think there should be some standards for how we think about funding universities.
Yeah, on the academic freedom front, Keith Whittington recently wrote a book, mostly directed at right-wing. He was criticizing right-wing efforts to rein some of this in. And I'm ambivalent because I actually agree with Jane Stanford to a certain extent. This is one of the early academic freedom battles where Jane Stanford, very, very conservative, created Stanford University, and she didn't like that there were getting progressive economists and social scientists at Stanford, and she basically said, this is my money, you're going to do what I say. And this was one of the first statements of the American Association of University Professors of the idea of academic freedom, that once a professor enters a university, he then is just in this untouchable bubble. And I don't know why you guys, professors, should be the one people that don't get any oversight. It's sort of bizarre. And so why shouldn't, a part of me thinks, and this goes to Gail's point of the ability to craft different types of institutions, why shouldn't donors or the board of trustees be able to say, we want this type of university and not that type of university? Why should professors walk in and say, I am now untouchable? So to me, it's not an obvious answer how the academic freedom thing should come out.
There's a point that in, I don't know how many people have read Friedrich Hayek's Constitution of Liberty, but one point he makes on behalf of inherited wealth is that it's a good thing for the society as a whole to have a class of people who aren't afraid of anybody and who aren't accountable to anybody, and that encourages independent thinking. That is, I take it, the case for having tenured faculty, very much like the case that we heard earlier today for life-tenured judges, to have people who aren't scared of anybody, but it comes with an obligation to be a gatekeeper. I mean, there's no gatekeepers for who inherits wealth, notoriously, and you get a very heterogeneous population. Here you have to show some professional chops before you get into this class. It's good to have a class of such people, but they need to be accountable to professional standards. That's probably overall better than being accountable to the donors.
I don't know, it seems to me that in the last generation or so, the sort of cohesion of particular academic disciplines has just disappeared, so that we don't have the basis that they would have had maybe in the early 20th century of, hi, we are sociologists, we know what sociology is, we know the good practice of sociology, we know careful sociologists. It seems like it's so disorganized now that I worry that tenure doesn't have the effect that it was supposed to have. I have no optimism whatsoever for the notion that you'll get more intellectual diversity today if you have more tenuring. I agree, however, that like the lumpen faculty, the faculty that is like living from hand to mouth, that's a problem, and they are terrified of the administration. And, they will not speak up at all. I've spoken to many people that are in this category of not tenured, not tenure track, don't know whether they're going to be assigned a course next semester or not. And some of them are conservative, but they would never say so. Still, I don't think that we're in a position right now to create intellectual diversity on campuses by having more tenured faculty. I don't think we're in that situation now.
There's one point Musa Al-Garbi makes in his book, which is that the lumpen faculty, the folks who go from, their grievances that, the tenured people are folks who are in, above the 80th percentile of wealth, of income in the United States. And if you're one of these adjuncts, you're maybe in the 60th percentile. It's still better off than most Americans.
Though with school debt, I'm not sure how far those measurements go.
But you lose the independence.
What can the law do? There's been some talk of legislative solutions, executive solutions. How much do we jettison? Is this a matter of reframing the Civil Rights Act and the civil rights laws? Or is reform impossible because the very existence of these kinds of theories is the problem itself? What are we looking at in terms of a remedy, and which branch do we see it coming from?
So I would see it as a combination, both there's like some what you could call deregulation and some what you would call more aggressive enforcement. I think that dialing back on really revisiting disparate impact and the practices of classification would be a big step forward. That sounds in a deregulatory mode, I think rightly enough. At the same time, much more serious enforcement of disparate treatment liability and keeping that focus on that core protection, the thing that's in the text of the 1964 Civil Rights Act, would indeed be very valuable. The thing that I'm personally uncertain about, and I think people in these circles really ought to be thinking about, is whether and to what extent some kind of viewpoint protections should be considered for inclusion in employment discrimination law, maybe particularly at the state level. But there, I think we've seen over the last couple of years really rather rank corporate America discrimination on the basis of viewpoint and ideology. There are trade-offs, there are downsides, but I think it's worth serious inquiry.
Jonathan reminded me recently that we'd had this conversation before, and I'd forgotten about it.
Let's have it in public now, Gail.
Okay, let's have it in public. I'm against it. You don't want to have viewpoint discrimination laws because sure as you are born, there are a lot of weird viewpoints out there, ladies and gentlemen. And like, you don't want to say, well, I'm a Nazi and they wouldn't hire me in the hospitality industry. That's not going to be helpful. And in academia, I absolutely guarantee you what will happen. It will not be more conservatives are hired. It will be more absolutely nutty viewpoints will have to be hired because they will threaten to bring lawsuits. When you protect viewpoints, you are going to find that 1,000 flowers start blooming, and they won't all be pretty flowers. And so please, 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 let's not protect viewpoints because you're going to find there's some weird ones out there and that we will breed them. I mean, even if people don't have weird views now, they will when they realize that will protect them.
I'll say, again, as representative of the redistributive left, there's been an aspect of affirmative action that has always been performative virtue signaling, and racial justice on the cheap. So, frankly, to the extent that it functions as a safety valve, we don't have to think about the larger inequalities because look at the number of black faces. I am perfectly happy to stop up that safety valve. The black-white wealth gap essentially consists in the fact that the 20% of whites who have any significant amount of wealth at all have a lot more of it than the 20% of blacks who have any significant amount of wealth at all. and that leaves a lot of people out. So yeah, I think that I'd like to be much more aggressive in redistribution than we have now, and so I can do without affirmative action, sure. I won't grieve.
Is the cause of this the schools or the consumers of what the schools are purchasing? I would imagine, and I can't believe I have to do this, that the university might say, oh, well, look, we're just providing the kinds of expertise, the kinds of managerial skills, the kinds of minds that are in demand from the private sector. So we'll happily rethink what we do if there were a different set of hiring criteria. Or is it that the universities are simply producing one kind of thought structure, and so private industry is forced to take whatever it gets? In other words, where's the chicken and where's the egg in this problem?
Yeah, I think they're simultaneous. As I say, it's codependency. You have the students that are being told that they're victims, and a bureaucracy that is telling them that they're victims, and the students then make a demand. And you have a faculty and an administration that is very far left. That's just the case. I mean, data after data show the skew, and I actually don't. I think political voting patterns should be irrelevant. I really wouldn't care if it was 90% Democratic voting, if people were committed to passing on the fruits of Western civilization with love and gratitude, and were dedicated to teaching students why they should be down on their knees in thanks for what they've been given by Western civilization. If they were all Democrats, who cares? But it is very left-wing, which today means a commitment to victimology and to oppression. And so, and then you have this incredibly toxic, vicious cycle where if so-called underrepresented minorities are not doing well, the answer is, well, you don't have a critical mass. And so you need to bring in more underrepresented minorities, and to do that, you have to dig deeper into the well of lack of qualifications. The problems get worse, and then the solution is more diversity bureaucracy, which then pushes for more diversity admissions. So it's something that is happening absolutely simultaneously. And how you get in there and smash it apart, I think, again, that's where it is going to depend, at least in the case of public universities, perhaps on just outside forces coming in and just trying to smash it up.
I do think that the concept of luxury beliefs also has a lot of explanatory power here, that luxury goods are those things that people are willing to expend excess amounts on, not for their utility, but often for their disutility. In an earlier era, an aristocrat might show off his wealth by having lace gloves. Lace gloves are not useful for working with your hands. You just show them off and you keep them in your vest pocket. Likewise today, the belief that men and women are fungible, for example, there's no difference between men and women, is one of those examples of luxury beliefs. And I think that one of the ways that you can start to change that consideration is maybe make some of these luxuries just a little too costly. And I think in the wake of this election and the shifts that we're seeing, I think there's going to be more and more pressure brought to bear on maintaining a lot of these DEI luxury goods.
I'll say the new administration does have a problem. If you were going to bring pressure on universities on these issues, you probably would do it through the Federal Department of Education, but you can't simultaneously do that and abolish the Department of Education. You're going to have to make a decision.
Think big.
One thing I would add, I don't obviously disagree that universities are to the left, but I think it's important to be specific about in what ways they are left. They are to the left on issues of identity. But if you look at the students who elite universities in particular actually produce and the jobs they send them out to do, about half of students at Ivy League universities go into consulting or big tech. So if these are hotbeds of leftist indoctrination and they're trying to turn students into Marxists, they're doing a fabulously horrible job, right? And so I think it's important to understand understand that universities are in this kind of tension where they need to replicate their donor base by piping students into a very specific and relatively constrained set of fields. And then on the other hand, the way they make up for that and do their penance is by spouting various sort of left-wing beliefs that in no way, shape, or form touch or threaten or challenge their bottom line at all. So I think there is a progressivism to the culture, but that exists in a dynamic relationship with this conservative imperative to continue to grow the endowment and to continue to replicate the donor base, which again actually gets back to the U.S. News and World Report question, because endowment is a huge factor in U.S. News and World Report rankings. And so there are all of these sort of perverse incentives, and I think the progressivism has to be understood in relation to what they're also trying to paper over.
I'd like to add that we're going to have a reckoning in higher education fairly soon. The number of students who are available to be paying the tuition is going down. And that's going to be something to look for and to plan for. If there are ways to make universities better, we need to figure them out now and figure out how they can be pressured into being better, because their budgets are going to be looking pretty bad. This is going to be very, very, very important. And if they end up cutting DEI, instead of the anthropology department, then that's a good thing. How can they be encouraged to do that rather than cutting actual academics? That's something important that needs to be thought about, and we need to make sure that when the cuts come, they come to the administrative bloat and not from some other part of the university.
I just want to, I have 2 words, October 7th. We haven't talked about that today, but if anything should have been a wake-up call to the country about the insanity that prevails on college campuses, it was the sight of these hordes of students out there basically cheering on Hamas. And they were part of an intersexual coalition. They were not an aberration. They were following the logic of post-colonialism. This is not something that will be cured by anti-Semitism, bias training. This has been a big mistake among the opponents to the student hysteria around the Hamas attacks. This is something that is inherent, that worldview is inherent to the university at this point. And it puts the universities, to the extent they even care to course correct, in a very difficult position. Because again, it's not just that they have been taught, you can't just tell them don't use certain phrases. It's an entire outlook that defines now the academic worldview, which is the West is oppressive. We hate Israel because it is the embodiment of the West. It is meritocratic. It is successful. And it sort of identifies as white. Israel is just a symbol for everything that the left hates about Western civilization. So that should have been a wake-up call. We had some donor revolts, especially at Harvard and the University of Pennsylvania, MIT to a certain extent. It's kind of fizzled out, and the universities are back to kind of keeping their heads underwater. We'll see what Virginia Fox continues to do, but that really was a moment of what should have been a complete wake-up call, and it's very hard to keep attention focused on it, but let's not forget how bad things really are.
Just to liven up the panel a little bit, I haven't yet disagreed with anything that Heather said, but I think what she's describing is a left, not the left. The left is fragmentary. There are factions of the left. Unlike the right, I know that you guys are unanimous about everything and never disagree about anything.
We'd love to have you join the conversation. There are microphones throughout the auditorium, so if you could make your way to one, we'll be happy to take your thoughts. I think there's one here in the center row. Let's start there.
Chuck Hurley, Iowa. I have kind of a sensitive, politically incorrect question for Ms. McDonald and anyone else who might be willing to answer. You referenced something of great importance to we lawyers and our clients, that of President Biden picking judges based on group identity, potentially being very bad for our jurisprudence. He kept his pledge to appoint a black female to the Supreme Court. Is that jurisprudential concern bearing out with Justice Jackson?
Well, you know, I actually didn't find her dissent in SFFA so appalling, unlike, I don't know anybody else who shared that view. But in general, without having read much more of her writings, I think it is, of course, a concern, just without speaking about her personally. But when you add an irrelevant criterion to a selection process like race and gender, by definition, it is mathematically guaranteed that the resulting applicant pool will be inferior to the one that you would have had without those irrelevant characteristics thrown in. So was Jackson, you know, the one person who was way out on the curve that would have gotten in anyway? Possibly, it's possible, but the odds are against any person within that who's been chosen on the basis of race and gender to be that most qualified person. And again, we need the most qualified people. You know, Biden gave us an early warning about what he was going to do. In February of 2021, somebody from the White House announced that it was no longer going to be submitting his judicial picks to the ABA for pre-clearance. And the reason given was because, get this, the ABA doesn't care enough about diversity. The ABA is just so colorblind, it's so rigid, and it doesn't hammer law firms like Paul Weiss for having, you know, white partners in their latest class. And so he was basically saying that my picks are going to be so bad that they're not even going to get by the ABA, which places diversity on the same par as judicial understanding. And at some point in the first 16 months or so of his tenure, it was either 22% of all of his judicial picks were black females. By one account, black females make up about 2% of the nation's lawyers. So even if you didn't have the skills gaps in law school graduation rates that Richard Sander, the UCLA law professor that is the progenitor of mismatch theory, has so ably documented, even if there were not those skills gaps, you're already knowing to go from 2% to 22%, something is wrong. And it's very, very worrisome because these judges are going to be with us for a long time. My other concern about the bench is not to do with diversity, it's the graduates of Harvard and law school. As we saw them out there chanting, the students chanting "Believe Survivors" during the Judge Kavanaugh hearings, any student who graduates with "Believe Survivors" mentality, and we know that the graduates of Harvard and Yale are disproportionately going onto the bench, that is the end of the presumption of innocence. That is the end of due process. And Yale and Harvard have a lot of explaining to do.
Let's go over to this side of the room.
Yeah, thank you. For our liberal Marxists, first, thank you very much for coming. I'll address this to Mr. Berry. The second part of our topic today is how do we move beyond identity politics, and I gather your answer is we should start, again, whip ourselves into a frenzy about income inequality. Let me ask you a question about the recent book that was headed up by a team of researchers, including Phil Graham. The name of this book is The Myth of American Income Inequality, where he looked at income levels in the US and affected them for transfers, government transfers and taxes, one pushing down levels, the other pushing them up, and he found the bottom 60% of Americans all earn about the same amount of money, whether they're working or not. So congratulations, you've already won. Would you not agree that looking at income levels in the US without taking into account these enormous efforts to equalize and redistribute already shows a distortion in the data? This is the world of reality, Mr. Koppelman, very similar to what Heather McDonald was talking about, and simply diverts our attention from what we should be looking at as the real distinction of inequality, which is the effect to which communities focus on and cultivate personal responsibility.
Gosh, I think that's for me. I don't think there are any Marxists on the panel. My basic point was sufficientarian, that it is harder for people who are not already a part of the elite to get a college education than used to be the case. But the point, I guess Tyler used the term inequality more than I did. He's a Sanders guy and I'm not. I'm really more sufficientarian. The last big redistribution fight we had was over Obamacare, which was just about giving people the basic sufficiency that they need to keep alive. And in the bottom 20% of American workers, the proportion losing basic health insurance was steadily rising for years before Obamacare. So that's the fundamental concern. What the overall distribution is, I'm fine with lots of inequality as long as people don't feel squeezed. But on the question of whether people in fact feel economically squeezed, if people didn't feel economically squeezed, you guys wouldn't have won the election. So I don't know, you're simultaneously celebrating the fact that you won the election. You'd better have your eyes open about why that happened.
And I'd like to add on this that personal responsibility is absolutely the moral centerpiece of any well-ordered life, and it has to be. But it's one thing to say that, and it's another thing to say that sort of therefore public policy has nothing to say. It is the position of too many young men in this country today that they are bombarded with pornography, drugs, video games, and do not have ready access to the kinds of economic opportunity, the ways to be constructive contributors to build up families and communities in the way that was previously true in this country. I am not saying that top-down economic regulation is the right response to that problem, but again, the first step is admitting that you have a problem. I'll clap for me.
Yeah, I would add that, so I have not read that book, so I'm not going to criticize it one way or the other, but what I would say is, if you look at a variety of the metrics and the ways in which people get access to wealth in this country, one of the ones we've been talking about a lot is a college education. The phrase paying your way through college comes from the fact that you used to be able to pay your way through college. That's where we get that phrase. It's remarkable to think about, but you used to be able to be a bartender and pay your way through college. I have a father-in-law who bartended and could pay for Harvard. And so we're living in a really different world, and to say, income inequality isn't as large as some of the metrics say, maybe that is or isn't true, I don't know, but it is simply a fact that the engines of social mobility in this country, crucial among them, the education system, has become completely inaccessible to huge swaths of Americans, and that this inaccessibility, as was pointed out, is also a meritocracy problem, because if you can't afford to go to the best college, or if you can't afford to go to a college because you're working class and you can't put yourself through college anymore, that's a huge issue. So I wouldn't dispute the particulars of that particular study, not having read it, but I do think there's plenty to be concerned about in terms of income inequality in the U.S.
I think I totally agree with Tyler. On the other hand, let's also say what we've learned. Why are Republicans going to promote more people going to college? Are you kidding me? That's not who our base should be, and I think we've got to get away from this idea that both sides embrace, which is that college is the route to a stable, well-paid life. And sadly, And it's also, I guess this is the elitist of me speaking, I regret that we measure college now based on value added to income. I think it's an end in itself. Learning and knowledge is an end in itself. And Betsy DeVos, Trump's DOE secretary, made this an even more precise instrument. She not just measured every college's addition to salary, but every major. So how's classics going to survive in that? And I believe classics should survive, and not in its post-colonial state, but it's an original state as the study of Greek and Latin and the foundations of our civilization. But anyway, I hope that one thing that Trump does is to strongly valorize vocational education and the dignity of guys working with their hands and learning how to take machines apart and put them back together, and the idea that you're better off with some phony degree in marketing, which is just not a it's not a college pursuit. Learn German, you idiots. We've got to get away from that and stop making it easier to go to college. It should be more difficult. I would say cut by 90% of the student population. We're probably getting close to who should be going to college.
In the center.
Good morning. Michelle Roberts of BlackRock with another question for Heather McDonald. Mr. Trump's nominee for Defense Secretary is against women in combat. What do the data show are the results for women in combat, and are women in combat an exception to meritocracy?
I'm unhappy with Gates as a nominee. Are you talking about Gates or
No.
Hegseth? Right. I'm not thrilled about that, but I agree with Hegseth. I agree with Hegseth on this. I think females in combat units is an abomination because combat cohesion, combat readiness depends on combat cohesion. Let's put aside the obvious differences, as we have recognized on this panel, that male and female skeletons are different. Their muscular development is different. There is no way that any female, even at the top of the curve, is going to be able to pull out her buddy when he's got 200 pounds of gear on him and his legs have been blown out, and she's the one that's trying to get him out of that crater. It's not going to happen. But let's just put those aside. And let's also put aside the fact that in pushing, when the Army was pushing towards gender inclusion in combat units, they said, well, we're going to develop gender-neutral standards for physical fitness. We had gender-neutral standards. They were called the standards. If you're saying we're crafting new gender-neutral standards, what you're basically doing is saying we're watering them down so that we can get more females across the line. But I'm going to leave aside that problem. The real problem is eros. You cannot introduce females into a male environment without breaking that unit apart. There will be jealousies, there will be fistfights breaking out. I hear this goes on in Iraq because, you know, understandably, males and females are attracted to each other. That is not the way to build a fighting unit that is focused on a single mission, which is defeating the enemy. So it'll be very interesting to see if Hegseth stands by this. If he does, I will change my opinion of him and saying this was a wise, wise choice. And as far as data, I doubt whether it's been measured because it's so taboo. So I'm not aware of outcomes. There's a woman named Elaine Donnelly, Donnelly, who is on this issue. And so if you want to see what's been done as far as, is there any measurement as to how, you know, with the Marines, they did have different mixed race and mixed sex and non-mixed sex units trying to compete. And the mixed sex ones did do more poorly, without question.
As always, the best conversations end too soon. I have two important things before we adjourn, though. First,
The lunch program, I have been told, is a bit different than in past years, so you would do well to figure out which next session you plan to attend before selecting your meal, which you will then bring to the appropriate conference room. And having discharged that duty, my second task is to thank this extraordinary panel for its exceptional commentary today.
That was fun.
God, this light.